Jai Hind everyone. My name is Vishal Gupta, and today we are going to discuss about this topic, that is sources of law. Actually, it is part of third year students one of the subjects topic, and that is sources of law, and that subject is Constitution of India, Law and Engineering. So firstly, what is law? So as per a simple definition in a layman term, we may say that it is the system of rules which a particular country or community recognizes as regulating the actions of its members, and which it may enforce by the imposition of penalties. Suppose we have a country, and if there is no law, then what would happen? There will be a complete anarchy. So to regulate the people, we need certain laws, and people should be aware about them. Simply, it is a system of law, and which basically tells about how the actions which will take place against the people if they are basically indulged in any kind of crime. So if we talk about sources from where these laws they are basically derived. So firstly, the customs, which are divided into two parts, legal and conventions. We know that customs, they are simply the things, the rituals which have been practiced by a community or a group from a very long time. Then secondly, the precedents, which basically are very much helpful because it gives certainty about the cases. Thirdly, the legislation. Legislation simply means the laws which are basically made in parliament. So firstly, the customs. So it is a usage or practice common to many or to a particular place or class, or habitual with an individual. So here an individual is very much aware what the custom is, how it is to be practiced, and from a very long time it has been practiced by people. Here I told you when we were discussing about various types of various sources, so in which we saw that this custom is divided into two parts. First one is the legal custom. So it is a custom whose authority is absolute. So in the eyes of law, it is very much aware that there is a kind of custom, and this custom has been practiced by large number of people, and so it has got a legal recognition. So it is recognized and enforced by the court. Even the court, even the legal system of a particular country is very much aware that such kind of custom in actual exists. Second one is the conventional customs, or the usage that does not exist or arise out of any legal authorities, but here what is going on, it arrives out of an agreement between the parties. So parties, they have made an agreement between each other, and they basically, in case if one of the party violates the agreements or the terms and conditions, so at that time another party may approach to court. If we talk about requisites, that what are the characteristics which should be present in a custom, only then it would be possible to give that custom a legal recognition. So firstly, the antiquity. So it simply means that that particular custom has been practiced from a time immemorial. So from a very long time it has been practiced by large number of people. Secondly, the continuity. So there should be continuity as well. It shouldn't be that people sometime they follow it, sometime they avoid it. Such kind of incident shouldn't take place. Thirdly, the reasonable. So reasonable simply means that it should have some importance. It should show that yes, through this, if we are basically following such customs, then we are benefited in this particular manner. Then certainty, it simply means that there shouldn't be any kind of vagueness. Vagueness in the terms of that how it should be practiced. People, some people know, some people do not know, or they are basically following that custom on their own. Then there should also be the consistency, and lastly the peaceful enjoyment. The people who are basically following them, they shouldn't be happy from that particular custom. It shouldn't like that some people they are affected because of the custom. Nextly, the conformity with statute law. So certain laws which are basically made in a particular country are they following all or those customs, are they as per the laws, as per the laws of that particular country or not. This is an important thing, because here we may take one of the case of our South Indian, we may say sport or custom, which is known as Jallikattu, and in which we generally find that bulls, they are basically uh, they attack each other and sometimes they get injured. And lastly, the important requisite is, that is, it shouldn't oppose to public morality. So these are the various requisites which we have discussed, like antiquity, continuity, reasonable, certainty, consistency, peaceful enjoyment, conformity with statute, and lastly, not opposed to public morality. Now, the next source of law, that is the precedents. Precedents, it refers to a court decision that is considered as authority for deciding subsequent cases involving identical or similar facts or similar legal issues. In actual, what happens, we know that cases, sometimes repetitive kind of case may come in court, and in such incident, if court is giving some verdict and that verdict is different again and again, then what would happen? There wouldn't be any kind of certainty. So here, for ensuring the certainty, these precedents, they basically came into existence, where what was happened, that whatever decision is taken by court, in case if similar kind of cases they are coming again in front of court, then court will in actual analyze that in what conditions that particular incident took place, that particular crime took place, and then what will happen in case if similar kind of situations occurs, so at that time similar kind of decision would be given again in the next cases as well. So in the subsequent cases we will get to see the similar verdict, similar judgment given by judges. So precedent, it is incorporated in the doctrine of stare decisis and requires courts to apply the law in the same manner to cases with the same facts, and some judges have stated that precedents ensures that individual in similar situation, they should be treated alike instead of based on a particular judge's personal view. So here we are avoiding personal views of judges. Suppose different judges, if they are giving decision on similar kind of cases, so here for avoiding the personal biasness, personal views, what happened, these precedents, they basically play a crucial role. So if on the facts or issues of a case differs from those in a previous case, the previous case cannot be a precedent. So we have discussed this thing, that here if we basically want this precedent to basically help in decision making, here one important thing is that case, we need to analyze the situations in which that particular crime, that particular incident took place, and if it differs from the previous one, from the precedents, then at that time we cannot take precedent at that particular point of time. So therefore a prior decision serves as a precedent only for issues given the particular facts that the court explicitly considered in reaching its decisions. And precedent, it is generally established by a series of decisions, and sometimes a single decision, it can also create a precedent. It is not necessary that several cases have been taken place and after that we realize that we need to make a precedent from those cases judgment. Even a single case, if it has taken place in certain, if a particular decision is given, then there is also possibility then that particular decision may act as a precedent for subsequent cases as well. Then again, kind of precedents. So firstly, the original precedents. So here, firstly, what is going on? Precedent is created. Suppose a particular case comes in front of a court, and that court has realized that it is a unique kind of case, and court has given a particular judgment on it. then that particular judgment will act as a precedent for the subsequent cases. So it will be considered as the original one. Then secondly, the declaratory precedents. So here precedents which merely apply established rules of law to the particular facts of the cases. Thirdly, the authoritative precedents. So suppose we have High Court, and High Court has given some precedent, some judgment. So for the lower court, for the inferior court, for the session court, for the district court, what would happen? That precedent made by High Court, it will act as a authoritative precedent. And then lastly, the persuasive precedents. So here there is no obligation on court to follow that particular precedent, but here what we may do, we may try to convey them, maybe we may try to persuade that particular judge that such kind of precedent, such kind of judgment was given in a previous case, and you may also check it please and give the decision as per the precedents. So suppose at the same level, suppose we have court at High Court, we have High Courts of two states. So one High Court's decision, it cannot act as a precedent for another one because both of them are at the same level. And on the other side, if we talk about the authoritative one, here inferior courts, they are bound to follow it. So some of the reasons why we in actual use precedent as a source of law. So firstly, the final settlement, ultimately the objective of court, ultimately the objective of judiciary is to give a final settlement of an issue, so it may help in it. Then secondly, it will bring certainty that in such situation this particular crime took place. So in that case, we have already seen previous cases as well, and that previous cases, they may basically help as a precedent. So it will also bring certainty. Beside this, bring flexibility to law as well, because in case if situation, if conditions they differ, then at that time judges, they are given power not to follow the precedents, but they may analyze all the situation and they may give some new judgment as well. Then open scope for judge-made law, brings scientific development. And lastly, it helps in guiding lower court. It is highly important, especially for the lower court, because through the precedents, they need not to very much involved in the decision making, because the superior court, the higher courts or Supreme Court, they have already given some judgments, and those judgments, they can in actual help as precedent for the lower courts. Then primary and secondary legislation, which is the third source of law. So firstly, what legislation is? In the parliamentary system of government, primary legislation and secondary legislation, these are two forms of law. And primary legislation, it consists of acts of parliament or statute, and secondary legislation, these basically it is the granting of additional law making powers to another branch of government by an act or statute. So here what we are going to see, that here as we have discussed customs, we have discussed precedents. Third one, in the legislation, if there is a country which is following this parliamentary system, like in our country we have a parliamentary system. So in that parliamentary system, what in actual happens, here we find that parliament is in actual making law. Here in this picture we can see that parliament is in actual making a law. But if we talk about its types, then it is of two types, primary and the secondary. In the primary one, what is going on, that major decisions they are taken, and the some few decisions, and they are basically left for the secondary legislation. Like here classification. So in the supreme one, it is adopted by supreme authority of the state, example parliament. And if we talk about subordinate, so dependent for its continued existence and validity on some superior or supreme authority. So here parliament, it has taken decision, but now what is going on, that parliament or the state legislature, it has given some authority to the subordinate legislation or the secondary legislation, that up to some extent you can further define those laws which are made in at the level of primary legislation. So here primary law, when a parliament makes a law, called an act, it is binding. On the other hand, two branches of government, acts are made by a majority vote of the legislature, and the exact process differ in different parliamentary system. And in a bicameral system like in our country, what we see that there is a usually a lower house and an upper house, and a new law starts out as a bill usually in the lower house, and it must pass both houses before it can become an act. So judges and the courts, they have almost no authority to challenge the validity of a law. So here we are discussing about our country where we have bicameral system, two house system, lower house, upper house, or Lok Sabha and Rajya Sabha, and it is necessary for a bill to become an act to be passed from both the houses. Then a law created by the executive branch of the United States government or that of a state government as a result of primary legislation is called regulatory law. So this is the case of US. Then the secondary legislation, so the legislative branch of government often delegates. So here what is going on? We are delegating power. So primary legislation of the parliament or the legislative branch, it has basically given some authority, it has delegated some power to allow ministers to make secondary legislation. So secondary legislation, they basically include directives, regulations and decisions by commission or councils. Now the next topic, that is the structure of court. So in our country what we see that we have such integrated and independent court structure, where at top or we have apex court, that is our Supreme Court. Then at lower level we have High Court, and at bottom we have District Court, which is further divided into civil judges, small civil cases and criminal magistrate. So firstly we will discuss about Supreme Court. So these are some of the characteristics of Supreme Court and how it is given independence, because we know that in our country legislative and executive, they basically work almost together. So here what was happened, it was realized that the Supreme Court, it should given some independence, some freedom. So these are the characteristics which are in actual helping to our Supreme Court, so that its work, its employees, its judges, they shouldn't be influenced by executive. So firstly, the mode of appointment, it is completely free from legislative and executive branch of our government. Secondly, the security of tenure. Security of tenure, what it means that the terms and conditions or the duration to which a person remain judge, that is also secured. It shouldn't be that any person or any judge would be getting its retirement in mid of his working. And then fixed service conditions, so whatever benefits they are basically informed at the time of their joining, they will be given. Then expenses, all the expenses of the judiciary, they are basically charged from consolidated funds of our country. And important thing is that conduct of judges, it cannot be discussed in parliament. So whatever decisions which are given by judges, they cannot be discussed, they cannot be criticized in parliament of our country. Beside this, there is also a ban on practice after retirement. So if a judge has been retired from Supreme Court, then judges, they are not permitted to do further practices, because they may take undue advantage or they may influence the current judges. Then power to punish for its contempt, it is an important thing that they are also having power, that if people or if any party, if it is found in contempt of court, so this court is given such power. Freedom to appoint its staff, it is another important thing, because otherwise if it is unable to appoint its own staff, then there is possibility that executives branch that may basically influence. So its jurisdiction, it cannot be curtailed, another important thing, because the area, the judiciary area, it cannot be curtailed by executive or legislature. and separation from executives to avoid undue influence of executives, because in our parliamentary system what we find that executives, they are having more power. So in case if this judiciary gets dependent upon executives, then at that time executive may take undue advantage from the judges. Then if we talk about the overview of Supreme Court, so it is the highest interpreter of constitution of the country. So suppose we know that we have a very big constitution, and there is very high possibility that in a certain section that things all they are not very much cleared. So at the time of any kind of confusion, who will interpret, that is our Supreme Court, which is the supreme authority of judiciary, and it is given power to interpret at the time of any conflict or confusion. Beside this, basically it came into existence on 26 January 1950, and I hope that you all know where it is located. So it is located at Tilak Bagh, New Delhi. So in New Delhi, which we know that it is our country's capital, so here it is located. These are power and functions. So firstly, it is acting as a guardian of the constitution. Our constitution, we know that for we people, we are given power. So in case if it is found that we are not given our fundamental rights, or in case if it is found that the current government or existing government, it is not following the guidelines given in constitution, so in such situations what will happen, that Supreme Court will in actual play role, and what Supreme Court will do, it will basically guide to the government that whatever you are doing, that is not as per the constitution, and you need to take some steps, you need to check your conduct, that so that they basically work as per the constitution. Secondly, the original jurisdiction, which we have already discussed, that Supreme Court, it is given power of this original jurisdiction. So generally if a case comes which is unique, and similar kind of case it hasn't taken place in past, so at that time what would happen, whatever decision is given by this Supreme Court, that will act as a original jurisdiction, and it will be recorded in court. Then next is, it is the defender of the federation. Federation system, we know that in our country we have quasi federal system in which states, they are also given some power. So when they are given some power, and there is also possibility that because of the unitary features which are present in our country, the central government, it may try to take undue advantage, or it is not giving due diligence, due importance to state. So in such situation, the states, what they may do, they may approach to Supreme Court that we are not given such benefits, or the central government, it is intervening in the area of functioning of the states. So in such situations, what will happen, it will act as a defender of the federation. Then next is the enforcement of fundamental rights. It is an important thing that we people, we are given fundamental rights, but the question arises, in case if we are not getting our fundamental rights, then which party will be responsible to enforce, to basically help us to get our fundamental rights. So here the supreme authority, that is the Supreme Court, as well as the High Court, both are given this power, this responsibility of enforcing fundamental rights, and a person or a common man can directly approach to High Court or Supreme Court under the section 226 in High Court and 32 in Supreme Court. Then next is the appellate jurisdiction. So here what can be happen, that in case if in lower court or in a trial court certain decision is given, and the parties, they are not very much satisfied, so that aggrieved party, it may basically approach to High Court or Supreme Court for further analysis, for further decisions. Then nextly, the advisory jurisdiction. So it can also review, amend and overrule decisions of a trial court. Then it is also having power to review. Then court of record. So a court whose proceedings these are recorded and available as evidence of fact. So whatever proceedings they go on in a Supreme Court, they all are basically recorded for the future reference. Then next is the contempt of court, which we have discussed, that in case of contempt of court, what the Supreme Court can do, it may basically put fine, it may basically take suitable legal action against those people. Then next is, it is also having power of judicial review. So in the judicial review, certain decision, if it is given by Supreme Court, so people may file a judicial review and may say to Supreme Court that you need to basically analyze the decision which is given by you. Then this is the jurisdiction of High Court. So every High Court it enjoys original jurisdiction concerning revenue and its collection, cases of succession, divorce, etc. And in its appellate jurisdiction, it hears appeals from the lower courts in case concerning sale tax, income tax, copyright, patent rights, etc. And the High Court is a court of record, and its proceedings and decisions they are referred to in future cases. And High Court can issue writs for the enforcement of fundamental rights or any other such purpose, which we have discussed in Supreme Court as well, that only two courts, High Court and Supreme Court, they are given this power of enforcing fundamental rights. So under Article 226, what we find that these High Courts, they are given such power. Then a High Court supervises the working of all subordinate courts and frames rules and regulations for the transaction of businesses. Because here what is going on, that High Court in a state, it is the supreme authority of judiciary in a state. So that is also having responsibility to check, to supervise the working of all subordinate courts. So all subordinate courts, they will work under the guidelines given by High Court. And the High Court is empowered to interpret the Constitution of India, and it can review the laws of the state legislature and may declare them null and void if they go against the provision of the Constitution. This is again an important thing, that at the state level we are having High Courts. What they are doing, they are basically reviewing the laws of the state legislature. Suppose a state, it has made some law, it has passed some bill, and that bill has become a law, and later on it is found that to some people, some party, they feel that that particular law is against the Constitution. So at that time they may firstly approach to High Court of that respective state as well, and may basically file a case against that particular law, against that particular bill, and then finally High Court will basically analyze that law, and it may have power to declare that particular law null and void if it goes against the provision of the Constitution. And again, if a High Court is satisfied that a case pending in a lower court involves a substantial question of law as to the interpretation of the Constitution, then it may dispose of the case itself. So again, it is an important thing is, suppose a case is going on in a lower court, but that case is highly important. It is having a substantial question of the law, especially on the interpretation of our Constitution. So at that time, what High Court may do, it may basically say to High Court, to lower court, to pass that case in High Court, and then that High Court will in actual take stable action. It will give its judgment on that particular case. Then the last type of courts, or the lower court, which are also known as subordinate courts, and they are further divided into three parts: Court of District Judge, Court of Session Judge, and third is the Revenue Court. So here all the civil matters they will in actual analyze in the civil code. Cases like land, property, money, transaction, frauds, all such things, all such areas they will be basically discussed or listened or sorted out in the district judge court. Then in case if there is any crime takes place, so in such case, in such situation, what will happen here? Cases related to murder, loot, deceit, theft, they will be handled in session judge case court. And then thirdly, the revenue code. So here it will deal with land revenue, agricultural land, etc. So such matters they will be discussed in revenue code. Now question arise about this subordinate code. So these subordinate codes they basically discussed in our constitution from article 233 to 237, and we know that these are also known as lower court, and it is present at district level and works under the high court. Now qualification and appointment of district judge, this is again an important thing, that how people will qualify to become a judge of a district court. So first and foremost thing is that that person should be citizen of India. Secondly, that person shouldn't hold any office in central or state government. This is an important thing, because if that person is holding such offices, then before joining as a judge he need to resign. Then thirdly, he need to resign from those offices. Then he should have been a lawyer or pleader for 7 years or more. So that person should in actual basically have some experience, some practice experience of minimum 7 years, only then he would be permitted to become judge. Then he should be recommended by the high court. So high court is not only responsible of supervising the lower court, but it is also responsible for basically appointing judges of lower court as well. So he is appointed by the governor on the advice of the high court. So high court is playing an important role, and here it is advising to governor of that particular state that this person, this particular lawyer, this particular pleader is basically fulfilling all the criteria and is an experienced one, and he should be appointed as a district court judge. Here basically, as I have discussed about this subordinate courts. So in subordinate courts, basically these are further divided into 3 parts: the session court or the district judge. So here sub court, sub judge court, municipal court, and small court. So matters that how much money's matter is related, on the basis of that that particular case will be sent to small court or municipal court or sub judge court. And similarly over here, that how much basically penalty, how much fine this particular session judge can impose, depending upon that these third class, second class, first class judges, they are given cases. And here again on the basis of revenue, upon depending upon the matter, how much rupees matter is coming, on the basis of that commissioner court, collector court, or tehsildar courts they are given. So that's all about today's topic.